Sikana, thank you very much. Good afternoon, almost, colleagues. It's a great experience to spend this time with you and to hear your collective views on alternative dispute resolution, etc. My name is Johan Venter. I'm a practicing advocate. I've worked for 50 years at the Department of Justice as a prosecutor and a magistrate, and left the NPA very disillusioned with how things unfolded there, and started a mediation practice. I have undergone training in family, medical, legal, and commercial, and I work in all those fields. I also do a bit of litigation here and there where things cannot be mediated if someone don't want to mediate. I'm also involved in a training space, around specifically family law mediation, and very passionate in that field. It's also fantastic to hear the heart of our previous speaker in respect of how he looks at things, and I share that passion of how do we look at ourselves, what do we stand for, what are we trying to achieve. So also, I think, similar to him, very frustrated with why things so easily become mediatable when there's no money left for the parties, and the narrative sold to clients. I think that is my big part of our frustration. I think we all need to learn that 7 habits of Kobe in respect of the inner circle. We can try and influence things from our inner circle, and hopefully that circle will grow and we will create more people that will become mind-like thinkers. And hopefully the students that are going to or participating here today are all convinced by the end of the day that mediation needs to play a very, very big role in how we practice mediation. The topic of our discussion is the impact and respect of court-annexed mediation, Rule 41, in family law matters, and did we see any real change? Rule 41 obviously applies to High Court matters, and court-annexed mediation in terms of Chapter 2 of the Magistrates Court Act impacts lower court mediation. Now, to my mind, there are a couple of reasons why it haven't really taken off. Firstly, a lack of understanding or trust from legal representatives and or clients. Often the financial implications for attorneys that I think is quite relevant. Asla, Lynette, and Linka also practice as a penalty coordinator. You so often see the missed opportunities that there were, and you speak to the parties, you see how things escalated during litigation, where things could have been settled much earlier, and then people like us end up as penalty coordinators trying to resolve those matters, trying to restore the relationships, often getting involved in reunification processes to allow contact between children and parents. And that's completely unnecessary. A lot of this damage that is done. And then in respect of the court-annexed mediation process, Sakana mentioned it earlier this morning as well, as how poor that rollout was. I was still working in the Department of Justice when that happened. No, except for some caravans that arrived at the courts, very little else happened in those courts where it was supposed to roll out. I think there was massive confusion in the Department of Justice, that is the custodian of the register of mediators that were appointed. And the courts, unnecessary or wrongly, held the minister, even with some of the champions of this project at the Department of Justice, to believe that court-annexed mediation also applied to family court matters. And it in fact does not. I will deal with that in a bit more detail. Now, court-annexed mediation in the lower courts that tend to address civil disputes, not family law matters. It also, if you go and look at a level of mediator that can practice as a lower court next mediator only requires an NQF level 4. Now, if we go and apply that in respect of the Children's Act, there's a clear difference there. If you, for example, look at section 53, it says a parenting plan may be developed by a family advocate, a social worker, or a psychologist. So it gives a clear sense of NQF 7 level qualification for specific interests and or skills around families and their unique situations. If you go look further, who can mediate the parenting plan in 53.5b, it refers to an other suitably qualified person or a social worker. Now, again, I believe that you need to read sections 53.5 A and B jointly. That other suitably qualified person isn't now all of a sudden the NQF level 4 person that have no training in family law, do not understand the mental health aspects around that, that do not understand attachment theory and all of the other stuff that are very, very relevant in family law matters, specifically when you deal with parenting plans. And then lastly, in respect of this slide, those NQF level 4 mediators also don't receive any training in family law. And therefore, they can never be the group that a minister intended to be involved here. And very importantly, court-annexed mediation is completely voluntary. The magistrate can only recommend the parties consider or discuss it, but can't enforce it. Mediated outcomes are confirmed by the court and also place no additional burden on judicial officers to apply their mind to the outcome between the parties in terms of Rule 82.4. Now, this is very important, and it very clearly distinguishes it from family law mediation, where the judicial officer is obligated to apply his mind to various different standards. Amongst other, Section 7 with the child's paramount, with the child's best interest. Section 9, respect of care for the child's paramount best interest. Section 10, respect of child participation. Section 11, in respect of medical health concerns around that child. Section 12, in respect of the religion and culture of the child. So there are various cues and different processes that requires a parenting plan for the magistrate to apply a judicial discretion to determine if that parenting plan is in fact in that child's best interest, and the voluntary process that is envisaged in respect of court-annexed mediation clearly then indicate that we cannot now quite as an equal process mediation to a court-annexed mediator in the family law space. In respect of the Children's Act, the objectives of the Act includes under Section 2 to promote the preservation and strengthening of families, to give effect to the following constitutional rights of children, namely B1, family care or parental care or appropriate alternative care when removed from the family environment. 4, that the best interests of the child are of paramount importance in every matter concerning that child. Now, parental plans are developed in terms of the Children's Act. And again, the Act specifically deals with this. The Children's Act also say that when it comes to matters around children, the Children's Act take preference over other legislation. And again, therefore, court-annexed mediation cannot apply in this space. 21(3)(a) says if there is a dispute between a biological father and mother, the matter must be referred for mediation to a family advocate, social worker, social service professional, or other suitably qualified person, as we've mentioned. 53.5, and this is now referring to a parenting plan, where 21 refers to parental rights and responsibilities agreement. 53.5 says the parties must, in terms of A, seek the assistance of a family advocate, a social worker or psychologist, or B, mediation through a social worker or other suitably qualified persons. Now, B is very relevant, and I think this is something where we need to pause, because this is where a lot of the wrong happens in so-called parenting plans. The word mediation immediately applies independence, a neutral person. A uniform, universal principle around mediation is a neutral person. And there are so many circumstances or situations where we as species find that attorneys representing a party draft these parenting plans. And they hide behind the fact that they're absolutely qualified person. Yes, they may be absolutely qualified people under different circumstances, but they are not neutral. The problem with that is that they draft, according to the client's truth, a parenting plan of what this client believes is in a child's best interest, and then we end up with a parent-oriented parenting plan and not a child-focused parenting plan. And that is a major concern. And I can't tell you, and that's also why I highlighted it in Linky and presentation as well, the importance of child participation, which often in so many matters the papers claim the parties complied with child participation, and yet there was never any child participation whatsoever. And we end up with these matters later as professionals in respect of parenting coordination. We often find this exact situation that children never had a right to participate in the process. Then in terms of 22.5, again here, very important, before registering parenting responsibilities and right agreement, or before making a parental responsibilities right with the order of court, the family advocate or the court concerned must be satisfied that a parental responsibility right agreement is in the best interest of the child. That aspect is very important, and it actually goes with the application of Regulation 8.3 and Regulation 8.4 of the Children's Act that deals with how child participation must actually be done. For some reason, the legislature apparently didn't feel it necessary to draft the requirements as a certificate for that purpose. And Regulation 8.3 and B falls in line also with a similar provision in terms of Regulation 11 that applies to Section 53 matters, and that's parenting plans, where specific people should be the ones that do child participation, and only certain people should explain that parenting plan at the age appropriate level to the child. And very importantly, the child's view, being informed of the parenting, must be recorded, whether he is in agreement or not, and if need be, that must be referred back to the parties to reconsider. Now, I've never seen in a divorce matter that document finds its way into the court papers. There's nothing more than a vermin to say that it was done, and that shouldn't be the case. There should be proper compliance in respect of child participation, and then we will see less of these matters where children's rights are simply ignored. I would further like to refer you to Section 28.4 of the Children's Act that states, when considering such applications, the court must take into account the best interest of the child, the relationship between a child and a person whose parental responsibilities rights are being challenged, the degree of commitment that person has shown towards the child, and any other fact that should, in the opinion of the court, be taken into account. Again, there, the important aspect for media is that it demonstrates there must be a proper consideration of the fact, and therefore this is not a matter where, in terms of a court-annexed mediation process, a court can simply rubber stamp. Then the Children's Act also requires the court to apply its mind to the outcome in respect of 54(1)(b), where it says a parenting plan must be registered with the family advocate or made the order of court. the courts act as the upper guardian of children and must consider the parental plan to determine if it meets the standards as we have already mentioned. Then child participation in terms of the Children's Act. I've already alerted to Section 6.5 earlier. A child having regard to his age, maturity, and stage of development, and a person who has parental responsibilities and the rights in respect of that child, where appropriate, must be informed of any action or decision taken in a matter concerning the child which significantly affects that child. The important aspect that I draw from this does not just apply in a divorce setting or in the development of a parenting plan, but it also impacts on how parents communicate with their children in respect of other important decisions made after parenting plans are finalized and that become rubber stamped, or rather have gone through the court process or rested with the family advocate. And this is critical. We've mentioned Section 10.11, but I think it's very important that we look at what it actually says. It says every child that is of such age, maturity, and stage of development as to be able to participate in any matter concerning that child has the right to participate in an appropriate way, and views expressed by a child must be given due consideration. That relates back to what I've mentioned in terms of the prescribed regulations, in terms of Regulation 8.3 and 4 and Regulation E11. Then Section 28.2 of the Constitution say the child's best interests are of paramount importance in every matter concerning that child. In effect, it mirrors in 28.2 Section 9 of the Children's Act regarding care. I would like to refer you to one or two judgments. Related by prosecutions Transvaal versus Minister of Justice Constitutional Development. The court said the right in terms of Section 28.2 imposes the obligation on all those who make decisions concerning a child to ensure that the best interests of the child enjoy paramount importance in their decision. Section 28.2 incorporates a procedural component affording a right to a fair consideration where the interests of children are at stake. In other words, what a child want is not necessarily what a child will get, but it must be at least a fair consideration of the feedback from that child. Whether that is now in respect of the development of the parenting plan or in respect of the child's feedback on the developed parenting plan. Sorry, the paramountcy principle, read with the right to family care, requires the interests of children who stand to be affected to receive due consideration. It does not necessitate overriding all other considerations. It calls for the appropriate weight given to the interests of children. The constitutional requirement is that there should be both substantive and procedural fairness before parents make decisions concerning their children. Practically, in this Pritwin judgment, it dealt with a father whose children were enrolled at Pritwin. There was, in terms of the contract with the school, provision made for disciplinary processes also against parents that don't comply with the decorum or rules of the school. The father in this matter created havoc in very different various scenarios, amongst others at sporting events at the school and in the school itself. There was proper disciplinary processes followed in terms of the contract, and eventually the principal decided to terminate this contract after the final written warning and informed the father to remove his children within a specified period of time. The matter eventually found its way to the Constitutional Court, where the court found that the decision to remove the children were correct under the circumstances. But the process to do so were unfair because there was no formal hearing or a process that allow them to voice their views of whether they should or shouldn't be removed from the school. The reason why the Concord found that a correct outcome in fact happened is because the children of this father, their rights were also limited compared to the rights of other children that should not be subjected to the kind of conduct that this father have to explain over a period of time. So the importance of this judgment is significant, seeing that it comes from the Constitutional Court. It is certainly something that we hope more practitioners will actually adhere to, not just claim child participation, and follow proper processes with people that are properly trained to assist them and finding suitable outcomes. Now, the impact of unnecessary litigation, Linky have mentioned it, Lynette have mentioned it, Charlene also. The consequence here is parents get stuck in fight mode. So they forget about the real interest, which is their children's safety and well-being, and it leaves the children in a very unhealthy space, being caught in the middle of the conflict. And attachments between the parents with the children suffer. There's often unequal distribution of time. Children are not really or don't feel safe to enjoy child time with the other parent. They always feel guilty because they know their parents don't want them to spend time with the other parents, etc. And that creates various challenges for children. It can escalate into depression, drug addiction, etc., etc., and spill over long term into their own abilities to form attachments as teenagers or into adulthood with their own partners and their own children. Now, what are the possible solutions? How can we, from our perspective, impact a change in how we practice mediation, or how the courts deals with divorce matters and Section 22 matters when it comes to considering the rights of children? Now, the obvious ones appears to me that the development of legislation, and Link is involved in that process with Linky, just helping you, what is it called? We guys developed the legislation, just to my mind now.
Sorry, you mean on the advisory committee of the Law Reform Commission?
Oh, that's the word I was looking for, the Law Reform Commission. That's a very long, tedious process that takes very long. Then trying to influence judgments to develop law and practice the directives in the different courts of how we practice these things. Now, practice directives is what I would like to discuss with you and explain to you what my thoughts are in respect of that regard. In terms of Section 63 of the Divorce Act, matters that fall outside the scope of the Divorce Act shouldn't be drafted into a settlement agreement, but should actually find its way in a parenting plan. And Section 63 of the Divorce Act actually provides very limited scope of what could or should be covered there. And if my solution proposal is that if it is any wider than the scope provided in 6.3, then the court should actually say, no, you need to develop a proper parenting plan and deal with it appropriately through a parenting plan and comply with the checks and balances that applies to the Children's Act. Let me give you a very practical example. If the parties on the 6.3 attend to contact and care of their 5-year-old child, and they say, we've complied with child participation, we spoke to our child. The questions come up is, what skill do they have to understand what a child's voice is? Or is the child simply told what a situation is? Or is the child told to make a choice? And all three of them aren't practical, and it should not happen. What skill do those parents have in understanding attachment theory and how to develop contact schedules if they do not have the necessary expertise? And the same applies to the family or rather the attorneys that draft those papers for the court. And where is the compliance with Regulation 11? And as soon as you throw everything under Section 6.3, the argument is, well, we do not have to comply with regulation because we haven't developed a parenting plan. And in that is the very reason I often find why settlement agreements are preferred to draft lengthy clauses regarding parenting plans into the document, but they don't develop actual parenting plans. I've provided for you here a copy of what I drafted, what I believe should be in the certificate. And the wording will be very similar in terms of Regulation 8.3 and 4 versus what I have proposed here. You'll see the last two paragraphs. The psychologist or the social worker will confirm that they understand the provision, that the children understand the provision of the parenting plan and are satisfied with the content thereof, or if they inform me that they understand the provisions, etc., but I don't agree, here are the reasons for it. And my train of thought is, if this is significant, and this document should be attached, then it should be even a confirmatory affidavit from the parties to explain why they have not changed that parenting plan, unless it is anything more than can be argued on the papers. Now, I've prepared a submission that have reached the judge president in the Northwest province, and I understand that they will, from the beginning of January next year, roll out a practice directive that is based on this reasoning. We say, if you want to exceed Section 6 of the Children Act in dealing with more around children, then you need to develop parenting plans, and you need to comply with the whole process around child participation and provide a certificate in terms of Regulation 11. Hopefully, this is where we could get the rest of the country to go to, and perhaps my parting thought to all of you is that if you can help us to sell this, if you've got contacts with your judge presidents, your regional court presidents, and your family law forums in the lower courts, then this will certainly help us to ensure proper accountability, to ensure there was, in fact, proper child participation. Then the perception that court-annexed mediation now provides the only framework for lower courts mediation to allow mediators, to practice is in other words wrong. The court-annexed mediators cannot practice in a family court unless they also meet the criteria to accredit as family law mediators. And family law mediators must in turn comply with requirement criteria to practice as court-annexed mediators. In conclusion, mediation provides a model complementing the needs of families in most matters. The legislation is there, we just need to apply it better and ask the courts to help us to apply it more effectively, to ensure that we don't impact children's rights and families' rights. And if we follow mediation, it will certainly help to retain the relationships, not just between parents, but between children and the parents, and create a safer environment for children that are from the divorced families. But thank you. That is the end of my presentation.
Johan, thank you very much. A very, very informative presentation. As a matter of interest, we have a very nice relationship with, you know, the High Court in Mafikeng, and yes, we are in contact with the Judge President at the court, and if we could add any value or assistance in that regard, you know, it would be our pleasure to get involved. Can I open the floor for any questions or comments? I see Linky's hand is up. Do you want to go for it, Linky?
Oh, I'm sorry that I asked so many questions, but I just wanted to tell you on that the Judge President of Limpopo, Limpopo Regional Court, the lower court, Jackie Wessels. I'm in regular contact with her. She's actually a friend of mine. So there we also have some, but they're the ones with the directive. I think it came from her. But anyhow, what I want to say to you is, I fully agree with you with the child participation, and that we need specific requirements for court-annexed mediation, and I appreciate your viewpoint that it's not applicable to family matters, but in practice it is. I did receive, I'm on the panel of the Magistrates Court in Pretoria, and I did receive a few from the clerk of the court, what do you call it, instructions from them with regard to mediation, not just family mediation, also other stuff, but definitely family mediation, because in the regional court, the regional divorce court falls under the civil courts. There are only the criminal courts and then the civil courts, and the regional courts and the children's courts fall under the civil section. So they think it's covered. I hear what you say, but in their minds, it's definitely covered. The court-annexed mediation rules are applicable to all civil matters, including family matters, children's issues. Okay, that's just the one thing. Not all court-annexed mediators should qualify as a suitably suitably qualified person, but some do. But definitely, I agree with you. Definitely not all of them. So that's just a comment. Okay.
Thank you, Linky.
I want to put my hand down, but
No, that's fine. We thought you had another question, Linky.
No, it's down now. Sorry. Now I'm quiet.
Thank you very much. No, colleagues, any other questions or comments for Johan? No, it seems like we have Mr. Taba. Welcome back.
Thank you, sir. I do have just one question to Mr. Fenter. Thank you very much. That was a very insightful presentation indeed. My question now falls to you. How do we get these children to be more involved in a way that they feel protected by the law? Does the onus now bear on the child justice legislation to maybe better improve the people responsible, for instance, your probation officers? Is this where now they will then have to play a greater role in ensuring that the children are genuinely being advocated for? Or are we now saying that there's a new open space to be infiltrated by upcoming legal practitioners who will then solely have this responsibility of ensuring that the child's best interests are indeed being put at the forefront, and not just on a paper, on just a legislative manner, but in a practical, realistic manner? Thank you.
Mr. Taba, yeah, thank you for the question. Look, as I said, I think the legislation is there. It is just the way that we practice or fail to practice it that creates the stumbling block. and part of that, it is a compounded problem. Perhaps the training of universities is a problem. Perhaps the training of judicial officers also is a problem. The fact there is not perhaps sufficient specialization amongst the judiciary, because family law matters, but specifically issues around children, is highly complex matters that requires extensive knowledge of a whole bunch of different things. Part of it is perhaps also that a legislator never drafted these forms in terms of the regulation is provided for it to be there, but it isn't there. Perhaps the problem is that a family advocate should have asked for these things when periodic plans go to them. So there's a multiple layers where things can be done better. My belief is that the existing legislation covers these things, but are simply not implementing it. The only way that we're going to deal with this successfully, I believe, is to seek judgments that will become reportable and help us to develop law, or to confirm firm law, or practice directives in a different courts to facilitate these processes. Unfortunately, there's, for example, also provision in the practice directives for regional magistrates that they should not consider a divorce matter unless they have a certificate from the family advocate. And I've discussed this with some of the regional magistrates that I know, and their view is simply, we don't touch it unless there is a signature from the family advocate. But invariably, if you hear how they respond, that it is almost a thing from once the family have signed it, it's a fait accompli. There's no need to, in many instances that I believe, from what they tell me, don't really need to then think about it. They simply rubber stamp. And that, to my mind, is incorrect. They are required to still apply the mind. And there's no reason why they, if they can properly motivate it or explain it or ventilate it, can decide not to go along with the endorsement of the family advocate. And I think that's a very, very important aspect. And as Lindy had mentioned, one of the things that we can perhaps look at to discuss with Jackie and those people, I know from my former life in the NPA, which is still a regional magistrate Pretoria, to develop perhaps those practice directives in respect of the regional court magistrates that will help us to roll these things out and enforce it through more comprehensively. But I also think, that that's how we educate in our schools. In respect of children's rights and those things, there's perhaps not focus going into many of these things that can perhaps be done better. But the long and short is, the legislation is there. It's simply that we don't practice or don't apply it the way that it should be done. Now, what I, for example, in my practice do when I mediate, I draft that certificate with all the details in, and I leave the two options open. I even put the psychologist details in there, and I give it to the parents and say, take it to the psychologist, here's a soft copy as well, that I'll email to you, etc. Once you have it, and I confirm it with the psychologist, when you've completed the process, print it, sign it, and give the handwritten one to the parties to attach to the papers that are submitted to court. I hope that helps to answer your question.
Thank you, sir. And I think you've actually raised a very important conversation as well in answering in answering the question, because looking at it from a higher learning perspective, yes, we're taught the law and we understand it on a legal basis, but now this is exactly where the stumbling blocks are evident. The things that we've neglected, the integrity in how we practice, the directives in which we actually really need to be making sure that we prioritize. These are things that I think the university should also start looking at and start teaching, maybe even from a first year level, so that when we leave, we're not just articulating legal documents, but actually know how to practice them on a practical manner. So thank you very much on that. And I hopefully it's something that will then get touched on in the near future as well.
Mr. Taba, thank you. Can I perhaps just mention, I just want to echo what the previous speaker have said, it comes to our personal value statements, how we practice law. What do we stand for? Are we giving these children a hand up or a hand down when we act as the attorneys or the advocates in these matters? Are we looking after our clients' interests and foresight that child? Do we facilitate these types of processes? Or are we all standing up, and all of us should as legal practitioners stand up and make sure that we protect these rights? There are so many judgments on this issue, and it's actually frightening that we even still need to talk about child participation. There was a recent decision in June this year that you can go and have a look at. It deals with a road accident fund matter, the Polokong judgment, where the curator ad litem in both those matters and attorney in both those matters, they were both involved in both matters, simply never made sure there was child participation and presented false information to the courts. In both those matters, they were referred to the NPA for possible prosecution and also to the Legal Practice Council for disciplinary action.
So with that being said, sir, and if you could kindly also write the citation in the comments just so I can go check it out. Are we now saying that those that are responsible for hiring our family mediators, advocates, and all these public servants in the legal field, are we then saying that there should be a huge focus on their morals and their ethics and who they and what they stand for? And should that then be the driving factor before they are even considered for employment? Because I think we can then argue that all applicants will be able to apply the law and understand it. So are we now paying a more greater focus onto the ethical and almost? Yes, I am. Okay.
Yeah, it is. It is very much it's a bigger debate that's out there. I simply believe that Section 10 makes it very clear we all must do these things. We all must. There is no debate. It is purely our choices how we deal with it. I've mentioned earlier that I do quite a lot of advanced training in family law mediation. One of the people in one of the courses last year is a practicing attorney. And when we dealt with child participation, she had a consultation even with counsel in the matter. And she said, we have this matter set down in court, but we never did child participation. And his view was, what the courts don't even look at these things, so let's not worry. And that's where the sin is committed as far as I am concerned. The going along with things that we know shouldn't happen. And what are our personal value statements? What's our personal ethics? Maria Ramos, in a presentation I attended many years ago in the NPA about ethics, said ethics is doing the right thing when no one else is looking. And I think that summarizes it. It is, what do we do when no one else looks? I think that's something all of us should daily do, irrespective of who we are and what we do. But for me, this is a thing that I'm extremely passionate about because I see the consequences for children or families.
Thank you, sir. Thank you.
Thank you.
Mr. Taba, thank you very much, Johan. I see there's one more hand up. Miriam, you can go ahead with your question.
Thank you. And yeah, thank you also for this exposure. I'm not from the legal fraternity or even background, but as a gender activist and a human rights activist, I have been greatly privileged to participate in this colloquium. My question is in relation to what the last speaker, is it Advocate Fanta, had said around ensuring the rights of children and families. Would this extend also to migrants, both documented and undocumented. I mean, you have indicated that this is a complex process and it involves a lot, but also I'm so happy to hear you saying you are evoking, the whole ethics around it, doing the right things when no one is looking. But my issue is, if this is happening to South African citizens, to what an extent are the migrants, both the children and the parents that are affected, to what an extent are their rights protected? I think that's the main question, yeah.
Okay, I think if you go look at section 28(1) in the Constitution, it says all children have rights, amongst others to be registered in the birth register, etc., etc. But that is a misnomer, because to qualify to be registered in terms of the birth register, etc., etc., there's a limitation clause. You must be a citizen of the country or born from citizens of the country. But when it comes to the right to have a say in decisions that is made about you, this right, to my mind, extend to all children, whether they are legal or illegally in the country. But except for those a couple of small limitations, for example, in terms of registration, national birth register, and so on, this right to participate in a parenting plan, the development thereof, etc., and any other decision that impacts on a child's right will apply. I want you to go back to the presentation. If you go look at section 10, I should have found it here quickly in my laptop. It's not as clear as see. It deals with section 10. Section 10 says every child that is of such age, maturity stage of development, has to be able to participate in any matter concerning that child, has the right to participate in an appropriate way, and views expressed by the child must be given due consideration. So in any matter that affects that child, there must be child participation. Whether that matter goes to court or not. And in most households where you are children, there's probably daily child participation. If you ask your child, what do you want for supper? What is that else than child participation in spirits for? Nee? Now that is an informal discussion that doesn't necessarily becomes now the joint consideration of both parents, because that is not the important choice that's being made. It's a smaller local arrangement between the mother and the child, or the father and child on that day. But when it becomes the decision around the schooling, as we discussed earlier, then both parents should be involved and hear what a child has to say. Can I perhaps just quickly, I know we don't have time, just briefly demonstrate to you how I demonstrate age appropriate child participation to parents when I mediate or if I do training. If your child goes to daycare at the age of 1 or 2, can he or she meaningfully contribute to the decision to what daycare you actually take that child? It is so insignificant unless there are some real other information that the parents will just make that decision. When that child goes to primary school, there may now be a friend or two that we've made at daycare or the creche, wherever you've been, that is now going to a specific school, and he might also happen to like the pink elephant on the wall painted outside of the school. So now at least there is attachment or a connection of two friends that have been there for 2 or 3 years, and based on that attachment, he says, I want to go there because my friends are going there. When he leaves primary school to go to secondary school, he now, apart from his 2 friends that are still part of his little band of brothers, might have a little girlfriend that is going to a specific school with him. He may have developed a specific interest in sport or in a specific field of academics that he clearly shows promise in. that certain schools will cater better for than others that you would like to pursue. So now there's much more for him to contribute to the discussion where he should go to school. When he leaves school after secondary school and go and study, well, he's now 18 and that decision should be his anyway, because he's now considered to be an adult. As a parent, I participate in it because I still have to pay for it and at least be consulted in the process, but it's pretty much his choice. And if he leaves school and starts to work and then receives in-service training, the parent is not involved at all because he's treated as an adult, and that relationship between him and his employer, they will determine what his further education is. But I think if you look at a very practical example, it demonstrates how a child's participation incrementally increase as his age stage maturity of development also increase. And that is the principle that parents need to understand. And what mediators and a council need to understand, and attorneys that develop these parenting plans, is that you're never going to meet a child's interest for proper child participation if the parents are fighting. Because the child's going to be in the middle of the fight and have to negotiate what should really happen in a family forum to make decisions with children. It can be so simple as, can I get a new bicycle, or increase in my pocket money, or a new computer, or whatever it is. And now the child's in a situation that they need to negotiate between the parent, and to an extent becomes a parentified child. Because he's no longer now the child, he now needs to manage his parents. And that is an unhealthy situation. And I wish attorneys that commit a cardinal sin of destroying these relationships and not mentor and coach and help the parties to understand the consequences after the divorce in many of these matters, get involved in. That being said, there's also many matters, and one of our colleagues have said it, that simply have to litigate. They will never solve that conflict, and the children will probably always be in the middle of the conflict. Does that help, Miriam?
Definitely, thank you.
You're more than welcome.
Thank you very much, Miriam. Thank you very much, Johan. I think it's it's very important that we understand that parenting plans and dealing with children is not a simple quick fix. There's so much intricacy, there's so much detail that needs to be put into dealing with kids specifically when it comes to alternative dispute resolution and divorce mediations, etc.